Good afternoon. Thanks so much for joining us. This is Time for Responsible Change, and we have the honor on ThinkTech Hawaii of having with us today some truly admirable, highly respected, high achievement people. Eh, We have Sandra Smith Gangle, a longtime labor arbitrator and author of a book called Madam Arbitrator. If you've got a handy, Sandra, and you can hold it up for us, we'd love to see it. We have retired Judge Sandra Simms from Hawaii State Court, also an author of Tales from the Bench, and Tina Patterson, esteemed arbitrator and mediator, and recent award winner of the 2021 selection to the cohort of Public Leaders for Inclusion Council of, I forget the name of the society, but my apologies for that. And also the award winner for excellence for the future award of the Center for Computer Assisted Legal Instruction for her work at Pepperdine University, Caruso School of Law, not to be confused with Cardozo School of Law, which is in New York. And Bill Harrison, just a wonderfully experienced and skillful criminal defense and civil rights attorney. And you sort of can't do one without being good at the other, right, Bill?
They come hand in hand. That's correct.
They do. Thank you all for being here. Responding to these times, one of the issues that is in front of all of us now is the police conduct and misconduct, and how to deal with it, how to prevent it, and how our various systems do that, and what might need to change for those to work better for all of us. And Madam Arbitrator, you want to lead us off? One of the areas that's different is in labor arbitrations, because many police are unionized, as compared to the criminal proceedings in court. Those are two different animals, right? What's the difference?
Well, thank you for asking, Chuck. And I'm honored to be here today with such a distinguished group of professionals in the business of arbitrating or conducting court trials where there is an issue of violence or misconduct. I think all of us have been greatly troubled by the events of this past year, and especially in Minnesota with the trial of George Floyd, the trial of the police officer who shot or knelt on the neck of George Floyd. And so these issues have been extremely troubling to all of us. And there's a lot of misunderstanding out there about the role of police officers and who are they responsible to, and how can they possibly be doing some of the things that we have seen them be accused of and now guilty of as a result of the trial in Minnesota. I've heard a lot of discussion in the media about the role of arbitrators, and that a lot of police misconduct cases go before labor arbitrators, and that at least half of those decisions of management in police cases get turned around, either reversed or reduced. There was an article that came out this year through Vanderbilt Law Review by Stephen Rushin on the whole issue of police arbitration. And I recommend that people find that online. And and read it because it discusses how arbitrators sometimes reverse cases. The problem is the misunderstanding that the public has is the difference between the role of an arbitrator in an employment case, a dispute between the union and management over a disciplinary issue, and a person who is accused of a crime in the justice system. There's some overlap because occasionally arbitrators do handle cases that could go before judges in criminal court. But oftentimes the case arises in the context of the officer's work as a police officer, and it never gets into the criminal justice system.
Right.
But the standards are different. An arbitrator looks at the collective bargaining agreement dispute resolution provision, which says management must have just cause to issue disciplinary action or to terminate an employee. An arbitrator has no power to find a person guilty and to commit that person to jail, for instance. The arbitrator's only potential award is to either uphold the discipline or the discharge or change it for some reason. And the arbitrator looks at, first of all, notice, did the person have notice that the conduct that is being disputed in the case was not allowed, was prohibited, and that if they did that particular conduct, they would be subject to discipline or discharge. And then they have to have proof, and it doesn't even have to be beyond a reasonable doubt in arbitration. It only has to be clear and convincing, which is a little bit less than beyond a reasonable doubt. But they still have to show, the management has to show that it had evidence to substantiate what it believes the police officer did. And then they have to implement a reasonable penalty. And if they find that that discharge is a reasonable penalty, the arbitrator looks at that and decides whether he or she agrees with that. And sometimes the arbitrator will say, well, there were mitigating circumstances. There was a case a few years ago where another officer committed similar misconduct, and all management did with them was issue a 30-day suspension. And therefore it would be unfair, it would be inconsistent to give a more serious disciplinary action to this employee. It could be that there was inadequate training, there was inadequate notice of the misconduct, and the employee has reason to believe that they were doing the right thing when they committed whatever the conduct was. So their standards are very different from the criminal system for a criminal conduct. So I'll stop here because I don't want to take up too much time.
Yeah.
So, Sandra, you've dealt with some of these as a judge, Bill, as an attorney. What's the difference between the two forums and the ground rules for each, and what happens in each of them?
Well, in the court forum, what you're looking at is a situation where it could be either civil or criminal. There's a criminal charge, and that's what you've had in the case of the officer in Minnesota. That's just a straight up criminal charge, and that just goes by criminal standards. And Bill certainly knows all of that. The other is civil, and it can be done on the basis of a violation of civil rights by the conduct. And then there's another process that can be done through the police department itself, and that's usually with a civilian review board, where people can file a complaint against a police officer within the police department, usually like we have here in Hawaii, the police commission. Here's those kinds of complaints that that people file. They conduct their means of determining whether or not those complaints are sustained. And having served as advisor some years back to that commission, meaning those complaints are not sustained. That commission also has the authority to, in some instances, do what arbitrators do in terms of doing discipline, but also referring the matters to be pursued in another forum. I think, Bill can kind of address some of those, how those things come up as well. Those are ways that these misconduct allegations can get addressed. Yeah.
Yeah, Chuck, actually, and I have to start naming folks like Sandra S. and Sandra G here because you got big Sandras. But both are correct in terms of what we do and how these disputes get resolved. As Sandra G says, whenever you have a collective bargaining dispute, it's based on your contractual obligations, both as an employer and an employee, and those disputes get resolved in that context. And then you have both the Professional Standards Office that used to be called Internal Affairs that investigates disciplinary issues within the department. And they're supposedly an independent agency within the police department, but we know how difficult that would be. Having most of those have been police officers, there still are police officers that are actually designated to that special task. And then you have the Police Commission, which is that civil body that basically are civilians who are there to at least have some transparency with the public in terms of what the public sees. And that commission generally has no power other than advisory, and that's where a lot of problems people are pointing to in terms of how these civilian review boards should operate. And so you got those three separate entities going on there, and then you've got the ultimate, which is the judiciary, which basically exercises the penalties in a criminal context if they believe that the police officers violated a law. And there's certain types of statutes that actually give the police some basis of immunity in the civil context as well as the criminal context for activities that they undertake. But they have to comply with the statutes with regard to any kind of conduct that they're involved in to not be drawn into the legal dispute in a criminal or civil context.
Thanks, and that's really helpful. Another point that Judge Sandra raised that I think escapes a lot of people who aren't familiar with our legal system is that besides the criminal case against former officer Chauvin, there is and can be a civil case, not only against the former officer, but against the police department and therefore the city or whoever's responsible.
Exactly. Yeah.
Irony is that in the criminal case, the better job the prosecutor does of establishing that this was off the wall, completely unsanctioned, out of bounds behavior by the former officer, the less culpable for it the entity, the police, the city, state, whoever it may be, looks. And so their prosecution of the former officer in the criminal case actually could work to their benefit in the civil case that Ben Crump brings for this and many other families. So there are not only differences, but root level inconsistencies that we're hearing here.
Yeah.
What kinds of reforms might need to take place in your experience as people who really know these systems well to reconcile the differences and make them consistent and coordinated in their administration of justice? Ideas?
Well, from the context of civil application to criminal laws, I think there's a real tension there, as you say, because clearly when plaintiffs go after police departments, they're going after police departments for remuneration. They want money, and the deep pockets are not the police officers themselves. The deep pockets are the city and counties and the state agencies that employ them, and so they want to get to the deep pockets, and so the state or the county, obviously, as you say, want to distance themselves from the criminal activity, and they look at it as an insurance company does. Most insurance policies say if you commit a criminal act, you're not covered under the policy, and that's what the cities and the state agencies are attempting to do, is to get to that position, and that's where I think Sandra G comes in, because the collective bargaining agreements are trying to limit that kind of attention, okay, and protect the individual employee as well. And so, that's the difficulty. You've got the standards and the involvements of the collective bargaining situation where the unions are trying to bargain for, more protection for the police officers, and the state and local agencies are looking to distance themselves in situations where there's criminal conduct. And so I don't know what the answer is in that context, and maybe we can refer to Sandra G and Sandra S as to how do we deal with that situation.
Yeah.
Well, as far as the unions are concerned, I think that it would be fairly easy for them to negotiate a provision in the contract agreement that violent conduct would not go before an arbitrator. It already is the situation as in the law of just cause that violence such as beating up your supervisor is a justification for discharge. It doesn't. It doesn't.
That's also a criminal charge.
Right.
That's also a criminal charge. You do
but
that.
now in the police in the police setting, it's they seem to they don't have that limitation where we will not represent someone just because they have committed violence. Because in the police context, the unions believe, well, that's part of their job. Their job is to carry a gun and a nightstick and equipment, and to be prepared to commit violence in the context of stopping crime. So they don't want to draw the line. So I think that again, it will come to some kind of negotiation between union groups and the management that they negotiate with as to how they might restructure their dispute resolution provision in some just way. There also are situations where the unions will not take a case if they feel that it's a loser. There's no obligation for that the union represent every employee who is being fired. The employee can file a grievance, and the union will usually try to negotiate with management, gather the facts, gather the evidence, do their own analysis as to the likelihood that this is a case that should be resolved by an arbitrator. But if they decide that no, this guy did what the management says he did, and he committed wrongdoing, he should not keep his job, and so we will not represent you. Sorry, but we're not going to take this case to arbitration. They already have that option.
Yeah.
So, Tina, you have experience with government responsibility and liability. Hey, how is the police situation different from general government responsibility for misconduct in your experience? Is this a different area of its own?
Oh, absolutely. It's a different area of its own. And I had the opportunity to attend a conference of law enforcement agencies in the fall. The problem, and I think Madam Arbitrator touched upon it, which is the confines of the collective bargaining agreement, but within the force itself, recognizing when an officer is abusing the force that they have, whether it is a lethal weapon or other training that they have, and literally pulling that officer either from public engagement or putting them on a desk assignment or completely asking them to move off the force. I'm seeing this locally where we are seeing officers that may be using a vehicle in a reckless fashion, that the vehicle is being taken away. I know when I was participating in our local police department, Citizens Academy, we talked about what the steps were. And one of the steps was undergoing mental evaluation, psychological evaluation on a regular basis. and that officer that is consistently saying, I don't need it, I don't need to undergo the evaluation, it's marked, it's flagged. And if you're consistently saying
okay.
you don't want to go, why? And at some point, you're not going to go out and interface with the public. So
Okay.
that's starting to, and it's because something is going on. The stress level, it's a stressful job to begin with, but if you are showing signs of extreme stress or that your response may be inappropriate, that's when either a superior or someone else within the leadership is supposed to step in and say, I think, Officer Harrison needs to come in. We need to have a talk with Officer Harrison,
Oh,
or Officer Harrison must undergo psychological evaluation. We're seeing some signs that concern us. The other piece that I'm seeing in terms of government, and I'll speak specifically about the jurisdiction where I live, in the past year, we've implemented a policing, and I'm looking at the write-up, a policing policy commission, and their focus is looking at best practices. But one of the other requirements, which I really was glad to see, was that every person who serves on this commission has to go through a 16-week program of the Citizens Academy so that they understand what the officers are going through.
right,
I don't want to go off on a tangent, but recently someone asked me what's the difference between a firearm and a taser, and I said it's significant. So in terms of the weight, the shape, and what it does. So I think adding those elements, one internally, looking at how do you address an officer, or when you see that a best practice isn't being adhered to, dealing with it head on, but also for those who want to serve on the review boards and the policing policy commissions, that they understand what an officer actually goes through from the
yeah,
moment they come into the academy to the moment that they are released out on their own. The ride-alongs will do that as well, where you spend an evening with an officer, but the Citizens Academy programs really give you a firsthand knowledge and opportunity to see why and how things occur, whether it's being assigned canine or the
okay.
person who's serving on the SWAT team.
Those are good. Those are good.
And
Good points.
so how do those missing elements get put into place? What's in the way of what's kept them from being instituted? Because they would appear to benefit everyone. The officers, the people they deal with, the communities, and the people who are responsible for training and administering those
Yeah.
officers.
I think it's multi-level. Part of it is the actual implementation. To tell someone that you're going, if I take an officer off the street, that means I've got one less person who is either involved in community engagement, or if I have an area that being surveilled on a regular basis. But I also think some of it is the tension between the public and law enforcement. And depending on where you're located, law enforcement is either considered protecting and serving, or not so much.
Not so much.
And it's that ongoing tension. We don't see or hear as many stories about the officer that helped a woman deliver a baby. We hear about them periodically, but we all remember, and it's burned into our minds, the person who hog-tied someone, or the officer who
Sure.
put their knee on someone's trachea for 9 minutes. We remember that. So there's this tension, but I also think what Sandra G said at the beginning is very true. And it's the understanding of what remedies are really available. I can remember my first time as an arbitrator. I shadowed a labor arbitrator, and there were some civil rights issues, but they were also in direct conflict with the collective bargaining agreement. And in the course of the hearing, the officer threatened everyone in the room, and the arbitrator was terrified.
Mhm.
So it's part of it is the human element is what
Yeah.
makes it difficult. Just sum it up.
I think there are some other things too that can be done. One is that the law of qualified immunity, I think, should be changed so that there is not that way out for police departments. I think that training itself needs to be more extensive than it is now. Police training is very short, and most of the training takes place on the job by following a supervisor. In the Chauvin case, he was the supervisor for the other 3 officers who were with him, and therefore they were probably at various stages of early training, and we're going to find that out in future litigation, I'm sure.
Yeah.
But they're getting their training from him. And then as far as the tradition of the blue wall of the code of silence of police officers, which is kind of a tradition where they don't testify against each other, that's got to change. And that has begun to change with the trial. There were many police officers who testified in that trial truthfully and were willing to testify, and that was a good thing. I hope that continues.
So in our last minute or two here, and we've opened up things that could go on for days. We've got mental health issues, we've got governance issues, we've got police conduct issues, we've got community relations issues. Judge Sandra, your thoughts to help us wrap up here.
One of the things, these are all, great concepts and ideas, but I recall when I was teaching a criminal justice class at Chaminade, and one of the things that the students do is they review different police departments and look at the challenges within specific, cities. And one of the students who actually had aspirations to be a police officer, he was assigned to, I think it was the city of Chicago. And one of the things he looked at is one of the big challenges. And one of the things that came up was the amount of money that was spent on lawsuits, civil lawsuits that the city had to pay. One student had New York, one student had Chicago, and they were appalled. And they said, if people knew this is the taxpayers' money that's being shelled out for police misconduct, if we look at things like the training, how officers are trained and other procedures, like, my God, he was just appalled. I think the sum was like $27 million in one particular year spent on civil lawsuits. And he's like, that could be schools, that could be addressing homeless issues. But instead, we're talking about police misconduct that we could have alleviated with some other methods. He says if taxpayers knew that was their money being spent in these civil litigations.
And it's all taxpayer money.
It's all taxpayer money.
The prosecution is taxpayer money. The civil defense is taxpayer money. The arbitration is taxpayer money.
Yeah. And I looked at him and I'm like, you got a point there. People don't realize that's where the money is coming from. You just sort of hear these numbers floating out there and you think, it's kind of, coming off the trees or something. But no, it's coming out of your taxes. So that's just
and as regrettably as we're out of time today, and I hate to have to bring an end to this because we're just getting into stuff that really is worth probably hours and hours more with people who have a lot of value to share. Sandra, Bill, Sandra, and Tina, all of you, thank you so much for being with us today. Please, folks, come back in a couple of weeks. We're going to keep diving deep into this stuff as candidly and as honestly as we can. Thanks so much. ThinkTech Hawaii, come back again.